is in session to consider the matter of clarity with regard to 6 recall petitions that were filed with the Calhoun County Clerk on June 1st, 2011. I am Michael Jackinet, and one of my duties as Chief Probate Judge is to serve as Chairperson of the County Election Commission. Present today as well are Ann Norlander, who is the Calhoun County Clerk and the Secretary of this Commission, and Ann Rosenbaum, who is the Calhoun County Treasurer. This matter is being recorded and minutes will be taken. Ms. Lowe, it is my understanding that we have complied with the requirements of the Open Meetings Act in that notice of this meeting has been properly given to the petitioner, the person who is the subject of the proposed recall petitions, and also that notice has been posted for the public interest. And have we, in your view, complied with the Open Meetings Act?
Yes, we have.
And there is an agenda that's been provided to the commissioners, I believe.
Yes.
And may I, well, I guess I'd like to make a motion for approval of the agenda. And
You'll make it. I'll support it.
all right. And are there any comments regarding the agenda? All right. I have one that I don't believe needs to be an amendment or an addition to the agenda, but I'm simply going to give notice at this time that it is my intention, following Commissioner comments, but prior to the vote or votes that may be taken today, I am going to take a 5-minute recess. And if there are no further comments, I'm going to ask for a roll call vote as to the approval of the event.
Okay, Judge Jackinet.
I vote to approve.
Judge Norlander.
Where will that take place?
That will be after the Commissioner comments, but prior to the vote that is taken. So it would be, I guess it would be 7A.
Sure. And Treasurer Rosenbaum.
Yes.
The agenda is approved. Also, I believe each Commissioner has received a copy of the minutes of the June 3rd, 2011 meeting, and I'm making a motion at this point for approval of those minutes.
Support.
And is there any Commissioner comments regarding the minutes? Hearing none, may I have the roll call vote as to the approval of the minutes?
Judge Norlander.
Yes.
Treasurer Rosenbaum.
Yes.
And Judge Jackinet.
Yes. As I've indicated, we are convened here today for a clarity hearing regarding the wording of 6 proposed recall petitions. It is our task today to review the recall petitions for clarity and clarity alone. It is not the responsibility of this Commission to pass on the accuracy or merit of the recall petitions, but rather to focus on the simple question of whether each reason for the recall stated in the petitions are of sufficient clarity to enable the officer whose recall is sought and the electorate to identify the specific transaction or transactions that serve as the basis for the recall, and to further give the person who is the subject of the recall an opportunity to mount a defense regarding the alleged conduct. This Commission does not review the reasons set forth in the petition to determine whether or not the reasons constitute misfeasance, malfeasance, or nonfeasance in office, or even whether the statements are truthful. The sole purpose of this hearing is to determine whether the recalls stated in the petitions are sufficiently clear statements of the reasons for recall. The recall petitions before the Commission today involve 63rd District Michigan State Representative Jase Bolger. The sponsor of the proposed recall petitions is Autumn Smith, who is a resident of the 63rd District. And the reviewable portion of each petition reads as follows. I intend to read them just one at a time. That which is labeled petition number 1 reads as follows. James P. Bolger voted in favor of the, quote, Local Government and School District Fiscal Accountability Act, close quote, also known as, quote, Public Act 4, of 2011, close quote, formerly HB 4214, Public Act 4, 2011, in Section 19 provides that an emergency manager may, quote, with approval of the governor, disincorporate or dissolve the municipal government and assign its assets, and liabilities as provided by law. Petition number 2 reads as follows. James P. Bolger, voted in favor of HB 4214, now Public Act 4 of 2011, the, quote, Local Government and School District Fiscal Accountability Act, close quote. This act in Section 19 permits state-appointed emergency managers the power to invalidate, without court order, legal and binding contracts entered into by duly elected local authorities. Petition number 3 reads as follows. James P. Bolger, I'll get it right one of these. James P. Bolger voted in favor of Public Act 4 of 2011, which grants state-appointed emergency manager the power to invalidate, without court order, legal and binding contracts entered into by duly elected local authorities. He also voted in favor of HB 4361, which will impose an income tax on some pensions of Michigan taxpayers. Petition number 4 reads as follows. For voting in favor of what is now Public Act 4 of March 16, 2011, formerly House Bill 4214-4218 and 4246, allowing emergency managers sole authority to remove local elected municipal government officials and elected school district board representatives from office. Petition number 5 reads as follows. James P. Bolger voted in favor of Public Act 4 of 2011, which grants state-appointed emergency managers the power to invalidate, without court order, legal and binding contracts entered into by duly elected local authorities. And petition number 6 reads as follows. James P. Bolger voted in favor of HB 4361, which will impose an income tax on some pensions of Michigan taxpayers. And those are how those 6 proposed petitions read. We will now open up the meeting to comment with the understanding that this commission may only review the clarity of the petition language and will not address the merits of the petition or the allegations contained therein. This will be the only opportunity for members of the public to address the commission today, and there will be a 10-minute limit for the comments made today, and that is a difference because of the number of petitions that are set for review today. We have increased the time for comments from 5 minutes to 10 minutes. I am of the understanding that either Ms. Lowe or Mr. Lindsay will be giving a 2-minute warning so that the speakers know when they're approaching their time limit. And I do intend to have the speakers stop at that 10-minute mark. So if you wish to comment when it is time for you to do so, please step forward to the microphone to be heard. And first, Ms. Smith, are there any changes to the proposed recall petition language?
The only thing that I may need to change is the title of office for which Mr. Bolger holds. It's been brought to my attention that may be incorrect. I will only change it if it's going to affect the decision by the Clarity Board. Seeing how I had the title listed in the same manner at the last hearing, and neither the Election Commission nor Mr. Gordon objected to this, I'm assuming it's not a problem and it's fine the way it's written. Should the Commission have a problem with that, I have no objection to changing the title of office to Michigan State House of Representatives District 63. Also note on the same token,
Well, let's, hang on there, just one second. Do you want that amended or not?
well, if it's not going to affect the clarity hearing, then, and it's going to be fine the way it is, then I'm not going to change it. But if it's going to cause an issue, then I have no problem with changing it.
And I understand that, and I want you to understand that now's your time to make any changes, so.
Go ahead, change it to what I just stated, to the title of office would be Michigan State House of Representatives, and the district would remain the same, District 63.
And you want that amendment made as to each petition?
As to each petition, yes, that's correct.
Michigan State House of Representatives.
We need a clarification for the ballot that would have to be prepared. If Terry could speak to it.
Oh, sure, go ahead.
The actual title of the office is Representative in State Legislature, 63rd District. That's the way that office appears on the ballot every 2 years.
So then let's change it to that, then, thank you.
All right, so is that what you're asking for all 6 petitions?
Yeah, because that was brought to my attention that that the objection was that office didn't exist, and so if it doesn't exist, I would ask why the representative is here if he's defending an office that doesn't exist.
Well, all we're doing right now is just asking if you want an amendment, not for argument. So the language would be what, Ms. Wilkes?
Representative in State Legislature, 63rd District.
May I raise a procedural point, or shall I wait till the other?
You should wait.
Thank you.
Representative in State Legislature, 63rd District. All right. That amendment is made to each of the 6 petitions. Are there any other changes that you wish to make to your petition language?
No.
All right. Do you wish to speak as to the issue of clarity as to any of the recall petition language?
Yes, I do. As previously stated, we're here today to discuss the clarity of the petition language as submitted. I would like it to be noted that at the last clarity hearing, I did take the Election Commission and Mr. Gordon's advice and removed words, phrases, and terms that were discussed and deemed not clear, which you can clearly see in Petition 5. So, anyone stating that the language is not clear, they would be arguing and contradicting not only with themselves, but with the Election Commission. I'm going to go through in somewhat of an order of the petitions and explain how my language came about for each petition. Petitions 1 and 2 are worded almost exactly the same, the only difference is being in the name of the legislation in which the petition is identifying. I fully named the legislation in petition number 1 by its specific name, included the House Bill number 4214 and the Public Act name. I did this for a few reasons. 1, because at the last hearing I was told that I had not properly identified the bill by what it is called and identified in the legislation. 2, I also included all of the names on this piece of legislation so that people who may know it by one name and others who may know it by the House Bill name would still both be able to understand this. The rest of the language is taken directly from the legislation of House Bill in which the petition is based. That would be House Bill 4214, Section 19, double C. So if one were to say this language is unclear, then you would be implying that the legislation is unclear, hence also implying that Jase Bolger voted on unclear legislation. In Mr. Gordon's objection, he states that I selectively quoted an excerpt of Public Act 4, 2011. That much is true. As stated above, I did quote from Section 19, double C of House Bill 4214. He states I quoted it out of context. I asked how can it be out of context when it is word for word exactly how the legislation was written. He states that this will confuse and upset the voters. Let me make one thing clear. The voters are not confused, and they're already upset. They're anxiously waiting and asking to sign petitions. Also, please consider that I'm limited to 200 words on the petition, and I selected a portion of the petition language in which the public is already very aware of and very upset about. On to petition number 2. Petition 2 is pretty much identical to the petition I submitted at the last clarity hearing, minus the words and phrases that were deemed unclear or contained opinion. I did ask the name of the legislation, and the House bill number. And Mr. Gordon's objection to this petition language, and the others as well, and he specifically uses Black's Law Dictionary definition. This is not what applies in this case. Recall language is specifically not supposed to be couched in legal jargon, yet he uses a definition of clarity that demands the use of exactly the kind of jargon he uses in his submission. The Election Commission needs to understand that the clarity is for the purpose of recall petitions is to refer to language that a normal person could understand and recognize what it refers to. He spent 15 pages clearly stating what he could have more clearly said in one paragraph of plain English. Petition number 3. It's the same as petition number 2, with the exception that I added the fact that Mr. Bolger also voted in favor of House Bill 4361, which will impose an income tax on some Michigan pensions. Mr. Gordon stated that House Bill 4361 is unclear because it could mean a bill from previous years. I find this preposterous because I blatantly state after House Bill 4361 what the bill does. Seeing that none of the other previous House bills have ever taxed pensions, I think it is very clear which House bill I am discussing. Another objection is that I use the word some pensions. I worded it as such due to the fact that, again, I am at a 200-word limit, and the fact that it would be inaccurate if I stated just the word pensions or all pensions. Some pensions are exempt from this legislation. If I was allowed more space to name all of them, I would have. But I'm sure that wouldn't have sufficed because it probably would have wanted every word for word of the details of each pension exemption, which I don't have room for. Petition number 4 addresses the other portions of Public Act 4 of 2011 regarding the emergency manager being allowed to remove elected school board officials along with the other local elected municipal government officials. As addressed in my previous languages regarding House Bill 4214, I named the Public Act and the House Bill. Again, due to the number of words I'm limited to, I was not able to go in as great a detail, but I was clear and concise in the words that I chose. Petition 5 consists of the language from the first hearing minus the unclear words and phrases. I named the specific legislation in which I am referring to, Public Act 4 of 2011, in clear, plain English, minus the legal jargon, and summarize what that Public Act does. Petition 6, again, states that House Bill 4361 will impose an income tax on some pensions. I again ask you to consider the points I made previously about this language. I blatantly state after House Bill 4361 what the bill does. Seeing that none of the other previous House bills have ever taxed pensions, I think it is very clear which House bill I am discussing. As for the objection to the form in which my language was submitted on, I received this form directly from Ms. Lowe, the Calhoun County Elections Clerk. This is the form that I was told is approved and prescribed by the State of Michigan Bureau of Elections. Also, it is the same form in which the NOS language was submitted on and approved. So should this commission not approve the language for this reason, I personally would view it as selective enforcement. In conclusion, I think that I have stated clearly in all of the languages for the recall, the reasons for the recall. I took the advice that was given at the last hearing and removed words, phrases, and opinions that this commission stated made my language unclear. Again, I emphasize that Mr. Gordon's objection to my petition languages, he specifically uses Black Law Dictionary definition. That is not what applies in this case. Recall language is specifically not supposed to be couched in legal jargon, yet he uses the definition of clarity that demands the use of exactly the kind of jargon he uses in his submission. The Election Commission needs to understand that clarity for the purpose of recall petitions refers to language that a normal person could understand and recognize what it refers to. Thank you.
Do any of the commissioners have any questions? Next is, I don't see the office over here, but Mr. Gordon is here. Do you wish to speak on Mr. Bolger's behalf?
Yes, I do. Thank you, Your Honor. Jerry Gordon from Dyke Gossett, appearing on behalf of Representative Jase Bolger. First of all, let me interpose an objection to the amendment to the petition as we sit here today. You now have a new petition before you. You don't have the petition that was noticed to Representative Bolger as the basis for recall. Now, the reason for the amendment is presumably because of the objections that we posed to that. We pointed out that Section 544C, with which the petitions must comply, is mandatory. It's even reproduced in the election law itself, and I've reproduced that provision in my letter, or in my objections. The fact that it was not raised before is of not relevance because we have a new petition here, the other petition was rejected to. So by amending this, you've created a new petition. My client has not received notice, the election law has not been complied with, and this amended petition is not properly before you now. So I would suggest that any approval of this petition would be inappropriate and directly in violation of the specific express notice requirements of the election law. Amendment, as you sit here today, is not permitted. The petition that is before this board is the petition that was filed and was provided to my client and then therefore provided to me. This other amended petition is not properly before you. Now, turning my comments to the petition that is properly before you, I would note that it does not meet the specific requirements of the election law. We've gone into great detail. As Clerk Norlander can tell you, there are certain requirements of the election law that are considered directory, and there are certain requirements that are considered mandatory. Those mandatory requirements of the election law are phrased in words of shall. 544C of the election law, MCL 168.544C, says a petition shall conform in the following form. It contains a place for the identification of the office and to the district. The petition that is properly before you says, identifies the office as Michigan State House. There's no office called Michigan State House. If you look at the Constitution that establishes the legislature of the state of Michigan, it speaks in terms of the state Senate and the House of Representatives. The election code beginning in section 168.62 and continuing on identifying the requirements to run for office of state representative, use the phrase representative over and over and over. It doesn't talk about Michigan State House. I think Clerk Norlander can tell you that when the office of state representative appears on the ballot, it's identified as Office of Representative, not as Michigan State House. Therefore, the petition that's properly before you and upon which we receive notice is invalid on its face. Turning to the 10-minute time limit, if I may, we set forth in our objections a due process argument that 10 minutes for an office holder who has a constitutional right to hold office is inadequate to address 6 specific petitions. That's slightly over 1 minute on each petition. We, assuming arguendo, and I don't agree that this is properly before you, but assuming arguendo it was, we have laid out a series of objections contained in the document that was filed before you, and I assume all members of the panel received those. So I'm going to briefly, I guess, blow through each petition to try to keep this under 10 minutes. Petition 1 just contains a selected quotation from 211 PA4 out of context. She only keeps those words that she believes apparently will confuse and upset voters to sign the petition. It's not clear. It doesn't provide something that's defensible or to allow the representative to respond to that. Petition 2 talks about the power to invalidate legal and binding contracts. Well, that's not what the statute says. That's not what it requires. If she's going if the petitioners are going to seek to try to paraphrase the statute, they have to do so in a non-confusing manner. This does not rise to that level. The phrase invalid has a specific meaning. It's defined in blacks. It's not set forth in the statute. Now the phrase without court order, what does that mean? That has no relevance to this. I think that's just to confuse and mislead the voters, and make the language, so-called worse than it already is. Petition 3 really mischaracterizes the legislation and misstates the effects. Talks about some pensions that it addresses. Talks about it imposes an income tax. Well, we make it clear that the income tax was imposed in the 60s. This deals with some petitions, but that's certainly not clear what we're talking about. How is the representative to respond to that? How are voters to know what she's talking about? What petitions?
Pensions or petitions?
I'm sorry, what pensions? Thank you, Your Honor. HB 4361. Well, we've raised that before. There is an HB 4361 at every session of the legislature. It's not defined with clarity. Now, the explanation given by the petitioner clarified it, but that explanation isn't on the petition. The fact that she had to give you an explanation in and of itself, I think, dooms this petition as far as clarity purposes. Petition 4 misstates the law. It says, emergency managers sole authority to remove elected municipal government officials from office. Well, that's not true. It misstates the law. It's unclear. The EFM has no authority to remove elected officials from office. The EFM can recommend to the governor that certain actions be taken, but Section 26 of the statute makes it clear that it goes to the governor. How is the respondent to respond to a negative? I didn't vote for this because it's not true. Well, it's just impossible. How is this clear to the voter? Now, you're right that the language doesn't have to be true, but the language identifying the conduct doesn't necessarily have to be true, but it has to be clear. And here, we're not identifying any conduct that is specific. We're characterizing a statute. That goes to the underlying facts that need to be clearly established. So she says he voted for this bill and then chooses to characterize the bill. Well, whether he voted for it or not may not be relevant because that's conduct that doesn't necessarily have to be true. But when you undertake to define the bill that he voted for, that ought to be clear, and that's not here. Petition 5 has the same infirmities as Petition 3. It talks about invalidate without court order and so on. Petition 6 has the same infirmities as Petition 3. And all of this is detailed in the document that we filed, and I'll rely on that. I will rely upon the analysis of the law I previously provided to this board at the earlier hearing, if I may. I'd like to incorporate those comments into this record, dealing with the statutory requirements. But getting back to the amendment here today, I cannot overstate my objection to that. You do not have that petition before you. And so apparently by attempting to waive or amend your petition, the original petition has been abandoned. The petition that you had before you today is no longer posed by the proponents of this because they stated their desire to amend the petition. That's fine. It acts, in my mind, as a withdrawal of the original petition. If they want to file a new petition, they can follow the processes and procedures in the election law, which are mandatory for recall, because recall is this extreme remedy we talk about. I hear the beeper going off. I will stand down. Thank you very much.
Do any of the commissioners have any questions on this board?
Are we here to vote on the language, or are we here to vote on the title?
I think it's all encompassed, because how can the language be clear or have any relevance if we don't know what office it's addressing? So I think it's all encompassing. I mean, if somebody came in and said, And I want to recall Jase Bolger from the office of dog catcher, and then set out reasons. Well, that's certainly not clear because that's not the office he holds. So here, when they misidentify the office, or don't identify the office from which recall is sought, I think that it can't be considered in isolation. I think you have to consider the totality of the petition.
Any other questions? Mr. Roy?
Thank you very much for your attention.
All right, are there any members of the public that wish to address the commission as it relates to clarity? And if you'll state your name.
My name is Pam Smith. I am from Athens, Michigan. Just as a layperson, listening to both sides, what my understanding is the amendment was to correct his title, which would then make the petition correct. If you've changed his title by the amendment, it doesn't change the substance of the petition.
Is there anyone else that wishes to address the commission?
I have a question for you. When you asked for any amendments to these petitions, were you aware that it changed the substance of the wording?
Well, I guess what, if I may address that during my comments,
Sure.
I'm going to address everything in my comments, if you'll indulge me that.
Sure.
Mr. Chair, prior to you making your comments, can I just add something? I just want to point out to the commission that MCL 168.952, subsection 3, states the Board of County Election Commissioners, I read all of it, shall meet and shall determine whether each reason for the recall stated in the petition is of sufficient clarity to enable the officer whose recall is sought and electors to identify the course of conduct that is the basis for the recall. And that's the end of the quote. The statute doesn't mention this issue specifically. I think it can be argued either way, but I think it's up to this commission to decide that issue. That's my legal opinion. I also will note that in 168.961, subsection 1, it states that the recall petition shall be filed with the filing officer, which in this case, because it's a state officer, is the state rather than the county clerk. And that individual has to determine whether or not the heading of the petition sheet is improperly completed. And that's subsection 2, small a, and small b of that statute. So I think what you're doing here is allowing her to make the change, which will enable the eventual filing officer to accept it. If it wasn't done, she would gather all the petitions, and then she would take it up there and they would say, you didn't change this thing properly. So I think it's a two-step process. This board just has to determine, in my opinion, whether or not the reasons are sufficient.
That was clear as mud.
Thank you. Talk to your legislators.
So much legislation is.
Well, if there are no additional comments from the public, what I am going to do now is make a motion for a vote as to the clarity of each petition now before the commission. And in doing so, my intention is to ask for a vote, this is based on the agenda, to ask for a vote as to each separate petition.
Okay, can I say something?
Yes, I would.
Prior to, which maybe I should just put in my names, but
Okay.
I do have a problem with Michigan State House. When I see Michigan State, I think of the school to the north and House to be credit. So I didn't have a problem with that. Now Ms. Smith has changed it to make it correct, and I appreciate that. But I don't know legally if she should not refile properly, as Representative Bolger's attorney said. And I don't want this to come back and haunt us. And Richard, you didn't help me because you're dealing with the exact same thing. I mean,
The safest thing to do is, and you know what that answer is already,
to disallow and make it come, and make it come back.
That's the safest thing.
And that's really what I'm dealing with, because it was mentioned that they could get all the names and then it could come back. And we would have inaccurately accepted a petition that was inaccurate.
Right. I think what could happen is you could approve the language, she could go gather 8,000 some signatures, and then she could take it to the state to file, and they would say, as Mr. Gordon points out, it's got the wrong name in it. And then they could reject it for that reason, as I read the statute, which seems to me not the right outcome if she gathers that many. So what you've done is modified the petition. So the two options, I think, are to either accept it and go forward at this point, would be accepted for the modifications that she basically made on the floor right now, or to treat this as another one submitted right now and then petition at another hearing. I don't see that the statute addresses it one way or the other.
Of course it does.
Perfect.
Well, let me, if I may,
All right.
go with your question.
Okay.
I have a question for Mr. Lindsay before we move on to my motion. It is my understanding that in clarity hearings past with my predecessor, Judge Reed, that there was always an opportunity for the petitioner to make an amendment to the petition at the beginning of the meeting. Is that correct or incorrect?
I have limited experience, so I'll refer to Mr. Long for that.
He has asked in previous clarity hearings if there were any changes that needed to be made in the language.
Well, I do think that this issue can be addressed in the commissioner comment portion further. And what I would ask is that we proceed on with the comments, and then if need be, we can take I'm open to suggestions from the commission whether the commission wants to address that issue separately or combine that with their vote on each petition should we get to that point. So, but I think that there does need to be some comment on not only that issue that's raised by Mr. Gordon, but also the totality of what's before us here today. So again, I am going to ask that, or I am going to make my motion again that we have a vote on each petition now before us separately.
I put that.
All right. And is there discussion? Of course there is. And I'm going to start. I don't agree with Mr. Gordon on the issue of amending the name of the office at this time. While I think it is arguable that the person that is going to be the ultimate arbiter of this in Lansing once petitions are submitted, I think it's arguable that that person could say that Michigan State House Common District 63 is improper. It may be, it may not be, I don't know. But I do look at this situation, the amendment of the form at this point as being something that we can take up today. If it were going to be language that were to be amended within the full body of the recall petition language, I could understand his point a little bit better than I do now. I would equate this to action that courts take in amending pleadings. That occurs all the time. You know, I understand this is not a court proceeding, and I understand that this is a very serious matter and does require that proper notice be given. But the type of notice that would be given if we were to accept what Mr. Gordon said, I think is taking that to an extreme that I'm not comfortable with. So I would, as one commissioner's vote in that regard, I would say that the issue isn't really can it be amended. It is amended. We've indicated that it is amended. The issue is whether that stops the process now and restarts our time period. And I don't believe that does. Excuse me, I'm going to be clearing my throat out. I do have great concern with how the petitions were presented to the commission today for our consideration. And I do think it's important to have some history made part of the record here. Back on May 25th, we dealt with a recall petition that was filed by Ms. Smith, and the language that was filed was deemed to be unclear by the commission, and that's a matter of record. That is what happened. The very next day, to my understanding, or the next business day, the petitioner resubmitted language, this time not in one petition, but in 6 separate petitions, excuse me, that clearly was not in the proper format because it wasn't even on a recall petition. That problem, as well as some other problems, were made known to Ms. Smith, and she refiled the language that's in front of us on June 1st. Excuse me. And when I read the petition language, it gave me great concern, because what the petitioner did here was something far different from anything that I found in the case law. It is true that the case law does allow multiple petitions to be filed. And the case, again, I cited this at the last hearing, I'll say it again here because it's the same case that deals with this issue as well. And that is the Demas case. Demas versus Calhoun County Election Commission. This is, again, a 2001 case. It is found at 248 Mishap 624. And in that case, there were a couple of different issues, but the pertinent issue as far as multiple petitions go was a situation where 3 commissioners were recalled, or there was the attempt to have them recalled. 9 separate petitions were filed against each of the 3 commissioners. The Election Commission accepted or found one of the petitions for each of the 3 commissioners as being proper, sufficiently clear, and 8 of them being unclear, rejected those. The appeal, in large part, deals with the decision of the Circuit Court as it relates to the approved petitions. 3 petitions were approved. The only difference between the 3 effectively was the name of each of the commissioners. And the bulk of the opinion deals with that situation, but then it goes on and gives some language that is instructive to anyone that wishes to file multiple petitions, and is also instructive, I think, to commissions such as this in dealing with clarity hearings. And it talks about how multiple petitions can be submitted, but it is in the context, as I read the case, dealing with separate allegations, which is far different from what we have here. What we have here is we have 6 petitions that have been submitted. 5 of them deal effectively with the same allegation, that is the emergency manager law. Two of them deal with the same allegation, that is petition number 3 in part, and petition number 6 deal with the income tax issue as it relates to pensions. And I'm not going to go into detail about specifically what they are as far as House number, they speak for themselves. Excuse me. But what you have here is you have a person, petitioner, that filed multiple petitions involving the same general allegation across petitions, and effectively has said to the commission, pick one or more. And I don't think that's our role. In fact, I'm certain that it's not our role. We are not here as editors for the petitioner, and that is one of the reasons why when Ms. Smith was up at the podium earlier, giving us our choice of, well, if it isn't going to affect it, I don't want to change it. If it is going to affect it, I do want to change the title. And I asked her, now's the time. Make your decision whether you want to amend something. Because we're not here to act as a multiple choice board. We are here to deal with 3 separate important groups, in my opinion. The petitioner is important only in that the petitioner has to be a qualified registered voter in the district, the same district as the person who is the subject of the recall. And also the petitioner has to meet the steps that he or she has to follow in order to get a petition before the commission and submit language that's sufficient for recall. That's obvious. That's a separate matter. The 3 groups that I care about, once that petition is in front of us, are the office holder, because the office holder has to have a sufficiently clear petition so that the office holder can answer to the language that is alleged in the specific petition. That's one. The second group that I am concerned with is the group of people that are asked to sign the petitions. The language has to be clear for those people to understand what it is that they are being asked to sign as it relates to the petitions. And even with those 2 groups, I think that the issue of multiple petitions with the same allegation across petitions is not as troubling. But with the 3rd group, the electorate, in the voting booth, it is a huge concern. And it is a concern because those people that go into the voters booth on election day have to make a decision based on what's before them on the ballot. I think that we have to operate under the assumption that when language is submitted by a petitioner, recall language is submitted by the petitioner, that petitioner wishes the commission to consider all of the petitions that are submitted. We need to operate under the assumption that that petitioner wishes this board, as she's argued here today, to find that the language in each recall petition is clear. And we need to assume that if we were to find that that language is clear, that the petitioner would be up to the challenge of accumulating sufficient signatures to get each and every petition that is presumed clear onto the ballot. And if that were to occur in this case, there we are dealing with a situation where that ballot is, in my view, unclear to the extreme. Because then we are dealing with a situation where the voter goes into the voting booth looking at petition 1, and the voter does what he or she wishes to do with petition number 1, yea or nay, and then they move on to petition number 2. And petition number 2 is effectively the same language dealing with the same allegation as in petition number 1. I believe that would be confusing to any voter. And the voter would be left with, I just answered that in petition number 1. And then you move on to petition number 3. And petition number 3 is effectively the same as petitions 1 and 2, with the addition of language that's mirrored in petition number 6, and so on. I think it calls for a unclear situation for the voter to deal with. And I think that it's incumbent upon an election commission to deal with that situation, because we are effectively the only board, or the only body, to pass on that which the voters are going to see in the voting booth on the ballot, assuming that the petitioner is able to gather the requisite number of signatures. I don't know why petitioner chose to submit the recall language as she did. But what was submitted here was in effect, a pick-em. We choose which ones out of the 6 we think pass muster. If they were for separate allegations, I think that would be solely and wholly within her, within her right to submit that. But I'm not willing to go down the slippery slope of multiple petitions dealing with the same allegation, whether it is 2 or 6 or 100. I believe that when multiple petitions dealing with the same allegations are submitted, they are per se unclear. I'm not addressing what Ms. Smith or Mr. Gordon dealt with as to the individual petition language, because I don't think that I have to. I think that I've made myself clear on what my concerns are. Ms. Smith, I will say this, Ms. Smith did, I think, did herself a disservice by drafting language that is arguably clear on each and every one of the proposed petitions. And I say arguably, we'll hear comments from the commissioners if they wish to touch on those separate petitions. But for whatever reason, chose to submit them in bulk as she did, and I don't find those to be clear. The other thing I want to put on the record is I have looked at the statute, and I have read every case I could find, both published and unpublished, in the Michigan case law, Supreme Court and Court of Appeals, and I could not find a similar situation. Couldn't find one. And when I say similar situation, I mean a situation where there are multiple petitions using the same allegations. So if the petition language is rejected, I have no idea what my fellow commissioners are going to do, obviously, but should they vote, as I will, to find this language unclear, I encourage petitioner to appeal this, because the law is unclear as it relates to case law in this regard. Likewise, if the commission finds that this language, any one or all of these petitions are deemed sufficiently clear, I encourage the office holder to appeal this matter, because I think that this is a gaping hole that needs to be addressed for the reasons that I've stated. But that is what I wanted to discuss here today, and those are my comments. Any other commissioner comments?
I will say this. I like the fact that you changed the title to what it is properly. And so Judge Jackinet mentioned it, I never conceived of perhaps 6 petitions on the ballot when you walked in. So obviously his rendering of it is very true and factual and could indeed happen, and that is very frightening to me as well. I truthfully would prefer to see something clean and clear. Clarity for the voter. And that's all I'm going to say. In other words, I agree with you.
And while I agree with some of what you said, you are making the assumption that all 6 would be placed on the ballot, and I'm not going to assume that would be confusing. And so if we do have 3 petitions that have similar wording, that shouldn't negate everything because we have 6 in front of us. The other thing that I'm totally confused about now is that we amended the section with the name, the office, and the district, which to my recollection hasn't been done before. However, in this office, to put this properly in perspective, James P. Bolger's name on record in our office is not such that it would appear on a petition. It would be James Bolger. And we would have to, in all instances, make sure that that heading was correct as part of our job, from what I understand, before these petitions are circulated. And that is my understanding, and Terry and I spoke about that at length, and went to case law to do so. So I would, in doing this, I'd like to take them separately, because I'm here to vote on the clarity of the language in 6 petitions, not the headings.
What I want to do and is there any further comment first?
No.
All right. What I want to do is I want to take a 5-minute recess, because I do think that the petitioner should be given an opportunity to withdraw petitions if she wishes to do so prior to their vote. And I want to give her an opportunity to think about whether she wishes to do that. If she wishes to do that, we'll consider that. If she wishes to not do that, that's fine as well. But I am going to move at this time for a 5-minute recess.